Well, we got to shift bases here towards some other contract and creative disputes. That's very, very interesting.
Yeah, let's talk about it. Like this whole thing with so for those of you not aware, Marvel is going through another legal drama. More legal dramas they're going through with Marvel. Apparently Spider-Man and Iron Man and a few characters are in like kind of legal jeopardy in regards to some of the heirs of the of these, you know, look, to kind of put it in a nutshell, the creators of these characters feel that they're entitled, or they feel like they have some sort of like ownership over these characters. And there are, from what I understand, some legal language where they could possibly regain some of these rights of Spider-Man and Iron Man. And Disney would have to share these rights with the heirs, the estates of these creators. Wild stuff, Dre.
Well, it gets even crazier than that. You say share, but you know the family feels they're entitled to 100%, at least domestically, to these rights, which is pretty insane. But I could butcher it, you know, but I don't want to do that. I don't want to do that to our viewers. So what I'm gonna do is I'm gonna play some audio from to show with Viva Frei and attorney Robert Barnes. Both attorneys are both legal experts in this field. Robert Barnes himself, what you're going to hear mostly, is been a civil rights attorney. He helped out Wesley Snipes in his tax case and such like that. He's been on the forefront of a lot of legal battles, not just with big corporations, but with also the federal government and state government. It's pretty interesting guy. So I'm going to play some audio from him, and he's going to break this all down. Now, again, understand that he's a civil rights attorney, so I understand his perspective and all this kind of things. He's not pro Disney, so to speak. Okay. With that out of the way, let's go ahead and roll the tape.
Let's do it.
So yeah, the backstory is that creators often sold their copyrights for very cheap, and were often, for a range of reasons, sort of sometimes hoodwinked, other purposes. The creative artistic talent did not get the financial remunerative award that they were really, as a matter of equity, entitled to from their own creations. And that also this would undermine creativity over time, that if you could screw over creators, more and more creators just wouldn't create or would do something different. And so as part of this copyright, they went in and amended the copyright laws to say, okay, after a certain time period, 36 years in some cases, 53 years in other cases, you can basically claw back your copyright, claim it back by saying, okay, I gave you a license, gave it to you for whatever reason, however long ago, but now the time period has passed where I get it back. And the way this also works is your copyright passes on to your heirs. So you have people who and the way you get it back is you can simply give a notice of termination that, okay, you've had my license for 36 years or 53 years. Now I'm bringing it back. And you know, maybe I'll give it to you again, but we have to contract for that. And what Marvel has done and what Disney has done, I mean, Disney, for example, the Disney mouse was supposed to be in public domain back in 1984.
This is true.
I mean, on multiple occasions, Disney has lobbied Congress to carve out special exceptions to allow them to keep their protection longer than, frankly, should have been the case. Because at some point, copyright becomes more about private monopoly than it does about rewarding artistic creativity. And what you have is you have corporate, and so this dispute actually arose before with Marvel some years ago, went up to the Second Circuit Court of Appeals in a different case, similar circumstances though, and the court made a crazy ruling. In my view, it was just deferential to Marvel, deferential to big corporations, that basically there's something in copyright called work for hire. Traditionally, that was thought of when I hire someone as an employee, and I as a company are on a project. Anything they do working on that project, the company owns rather than the employee owns. That always made sense. It was,
and that would be consistent with working relationships that Disney has had, you know, within the studio, right? I mean, if you hire an Iwerks and he helps create Mickey Mouse, that's still part of Disney and not Iwerks himself, right? That's work for hire. But these contracts, a little different, as he'll explain.
Ought to apply to all licensure situations. to where if you have a freelance person creating something and then a company pays them for it, that means they have it permanently, and that's a work for hire. But that's what the Second Circuit did. The Second Circuit basically converted all freelance work ever done into work for hires. All of a sudden, you were magically an employee all over again. And so that was a very controversial decision. Everybody in the creative community hated it, thought the Supreme Court should reverse it. These cases are going to bring that back. Now, the lawyer handling it for Marvel and Disney is Daniel Petrocelli, one of the most overrated lawyers in the world, man who single-handedly got his client convicted. If you want to get convicted easily, hire Daniel Petrocelli. His name to fame is he tried OJ on a civil case in front of a bunch of jurors who already said he was guilty before they sat down in the jury. Congratulations. How impressive. But that's about it. But this is a preemptive effort by Marvel to assert a continued monopoly and corporate control over all of and to convert individual creators' content that they slaved away to create on their own accord to never get the benefit of that, for their heirs to never get the benefit of that, to allow them to be corporately owned. And for a lot of us in this space, that was always a horrendous decision. There's a reason why Congress passed a law that allowed this. Again, you get it for 36 to 53 years, depending on the circumstances. This needs to go back to the people who created it. They were not employees. None of them were. And they're the ones who should get it. But it will have massive impact on Marvel, because almost every major Marvel character, Iron Man, Spider-Man, Doctor Strange, Black Widow, you name it, is subject to these. It was not obtained by an employee of Marvel. It was obtained in this other way, and could go back to the family or individuals.
But so
there you go. So,
it's interesting. I'm kind of, I'm torn on this because, I'm not a lawyer, I'm not a legal expert.
Yeah.
As a Disney fan or a Marvel fan, he mentions Mickey Mouse would have been public domain, or supposed to be public domain in 80 something, right?
Yeah. It would have. There's Sonny Bono law and a couple other laws actually changed that, but yeah, it would have gone to the public domain had that been the case. But go ahead. I think I know what you're saying. Yeah,
the thing is that I don't know if that wouldn't have been a good thing for Disney. Obviously, because not necessarily corporate greed, but you want to have, this is Mickey Mouse, for example, is the icon of the entire company.
Right.
You don't want to have everyone have access to that character in any way they want. You can make a Mickey Mouse movie that's very inappropriate, you know what I'm saying? Yeah. And you don't want to have that. And a lot of people aren't, the general public aren't as well versed in a lot of the stuff that we are. So, if there's a Mickey Mouse movie that's inappropriate, not made by Disney, right, but because the copyright, fell out and everyone can use it, the general public isn't going to know the difference.
Oh yeah, sure.
So for me, that's a problem as a Disney fan, and I can kind of see also with Marvel, the same kind of problems arising. It's a tough call. It's a really, really tough call.
Well, I will say this. I think there should be kind of different rules for a character or entity created under a corporate entity than there should be maybe by a single person, right? I think you could make the argument that if it's a single person and such, that if their work doesn't, if their work is supposed to live beyond them, how long is it supposed to live beyond them personally? Whereas you have a corporate entity who created this as part of a corporation who's still using it, that's a whole lot. That's a different story, right?
Right.
And I think we can delineate between those things. So no, I don't quite attach it to corporate greed. I just look. The Disney company, if they ever lost Mickey Mouse, they'd have to pivot substantially. They would have to pivot majorly, and I think it would do potential damage to that character more than it would kind of help, and more than it would kind of benefit this idea or this notion that this things should fall out of copyright and fall into the public domain. So I think there are differences there when it comes to this context, though. When it comes to these contracts or how they incorporate these characters into their books, this has pretty huge implications, because as Barnes pointed out, these relationships weren't, or I should say this content creation and production it didn't come from Marvel themselves. They contracted this out and incorporated in their books later on. And it was always the belief that Marvel, owned these characters outright, but apparently that is not the case. And at least domestically, these rights, 100% of them could revert back to the family. And if that's the case, then all those characters wouldn't be available for the MCU. And moreover, they could sell those characters to whoever they wanted to.
And we thought
Think about that.
We thought that the Sony thing was a mess. If that happened, oh my god! You want to talk about a shitstorm?
Oh yeah. No, absolutely. This could get hairy particularly quickly. So I don't know. If I was Disney, I'd be looking to do the same thing that I just did with ScarJo. I'd be looking to get on the ahead of this, reach out to the family privately and say, hey. Obviously obviously there's a dispute here. If in fact Marvel, didn't ever acquire these rights out, which it apparently looks like they didn't, then we need to buy these rights right now, and we need to put money down. We need to purchase these rights, from these family members who legally might be entitled to them. So that's what I would do, because you cannot risk this.
No.
Going to a judge or going to a jury or whatever. You just can't do it. There's too much money at stake. There's too much at stake in general for these, just have this kind of kind of this end of use kind of notion going out there.
Yeah, no, 100%, 100%. We're on the same page. I think that Disney should be proactive with this. Reach out to the estates.
Yeah. Try
to work something out. Say, hey, what can we do to kind of compensate you for this? I think that would be the best way to go about it. I do think ultimately, at the end of the day, I think it will work out for Disney.
I think so.
Yeah, I mean, I think there has been, from what I understand, some other cases similar, like with DC and things like that, like Superman, that have ultimately worked out for like Warner Brothers. I do think it will work out, but man, after ScarJo, this is the last thing they need, No,
I know.
Yeah, and then they have Mickey Mouse coming up for.
They do.
Yeah, like in 2028.
I think so. Which is. And we've talked about that before.
Yep.
But I mean, look, you say, hey, this is the worst thing that could have possibly happened. Isn't that interesting that on the eve of Scarlett Johansson, how her lawsuit kind of, flowed through the entertainment industry, so to speak, and kind of wrapped up the headlines, and all this drama with Marvel. It's very interesting how this all kind of just is packed into just this crazy year for Marvel. It's very interesting. It's very weird.
Is. No, you bring up a great point. I mean, look, there has been, as mad as some of these other Disney-owned studios have been, like Pixar has been, there's been sources saying, like, look, the people at Pixar are upset over, just dropping Luca and various films just onto Disney Plus, right? They've been upset.
Yeah.
But that's really where it starts and stops with Pixar. There really hasn't been anything else. There's no lawsuits, no, nothing. Marvel has been non-stop drama, whether it be the ScarJo thing, whether it be this thing with the estates, right? Whether it be Marvel actors and actresses coming out and slamming
Shang-Chi, Russo brothers.
Right? Exactly. It's Marvel thing after Marvel thing after Marvel thing. And look, I'm not hating on Marvel. What I'm saying, though, is like what you're saying is basically what's going on. Why is it all coming from just Marvel? Obviously, other studios of the Walt Disney Company have a lot of the same issues, but there doesn't seem to be the same public discourse with it, right? It's just Marvel. Why?
And it sounds like somebody's coming after Chapek again and is looking to undercut him any way they possibly can. That's kind of my feeling on it. I don't know who's involved. I don't know what's going on here. I know it sounds, oh, that's conspiratorial. How can you say that? Well, it's kind of weird, isn't it? It's weird how all this stuff, keeps coming up, and it keeps attempting to undercut the golden goose essentially for Disney. And it's I don't know, this it just doesn't feel right. Something doesn't feel right with regarding this whole situation, regarding this whole thing. It doesn't feel organic. It doesn't feel like the family was like, because Stan Lee, and I believe that's it's on behalf of their family, that's on behalf of his family that they're suing, or at least indetermination, whatever, where all this court case specifically has emanated from. He's been gone for a while, and all of a sudden now, I mean, isn't it kind of weird? It's very, very strange what's going on. It's very, very strange, and I don't know. I guess we'll have to just wait and see.